and adapt to changed circumstances. That's something I picked up in my time in the military. So with that in mind, let me share my screen here and show you where we're going here as we discuss contracts in a time of uncertainty with coronavirus. Here's our agenda. I will cover topics 1 through 4, and then my colleague, Danny Vincent, will come in to wrap us up and talk about a COVID-specific topic. So topic 1 here is back to basics, and that's the basic building blocks that you need to navigate a contract dispute and also make rapid decisions here in these uncertain times. Now, I know this may seem incredibly simple and reflexive, but here's an example of something else in our lives that's incredibly simple and reflexive, and that is, I need to drive to work. Where are my car keys? And how often do you find yourself, or at least myself, looking around the house trying to find the car keys just so I can do that basic building block task of getting to work and getting my day started? So that's maddening anytime it happens, and it certainly is maddening when contract disputes arise, and I consistently see this in my practice. Both where's the contract and what is the contract? And when I say what is the contract, do we have all of it? In the days of today with master services agreements, modifications, renewals, change orders, this can get difficult and also can bog you down very quickly. And I know this is something that in-house folks deal with all the time, so I'm preaching to the choir. So, you know, the lesson and the value here is for your business people as they are, you know, navigating their way through these kind of things, to know what their contract is, to have access to it, especially if your company doesn't have a contract management type system that I know many larger companies have today. Now, something we also run into a fair amount is, do we actually have signed copies of all the contracts? The good news is in Georgia, if the contract has been performed, often it can be enforceable, but again, infusing more uncertainty where you don't necessarily want to have it. And same thing with writing versus oral. Of course, Georgia does enforce oral contracts, but you're also signing yourself up for a likely fact question, which could involve a jury. And of course, you know, right now, we don't know when we're going to have jury trials again, and we also don't know when the backlog of jury trials that are waiting will clear. And of course, what does the contract say? All the lawyers here on the call know that going back and checking the contract language is the building block, but our business people often do business based on memory, based on recollection, because they're very busy. So they do need to be reminded to go back and check that contract language before they make a decision or take a leap that could incur years of litigation, hundreds of thousands of dollars in legal fees. Moving on. Do we have a problem? And of course, if we have a problem, what are the implications and the rights of that? So I've got here on the slide a spectrum of where we are on the problem thermometer, so to speak. Only it's getting hotter as we go further down instead of further up. Of course, concerned, nobody's breached yet, but the horizon is looking cloudy. Communication is very valuable and preferably written. Obviously, if you're trying to make decisions quickly, phone calls, you know, or maybe not today, but days of yore, face-to-face meetings would be the way to work that out. But it's even more important to make sure that that does get memorialized in some kind of writing, even if it's just a quick email. A breach will give you a right to money damages, but it doesn't give you the right to terminate the contract. This is something business people often don't realize. So it's important to keep performing and keep that tally of what it's costing you. And So you can reference back to that if litigation ensues. And then material breach. Now things are getting serious. This is a failure to perform that's so substantial that it goes to the root of the contract and defeats its purpose. This is when you start to accrue the legal right to potentially terminate. But as I'll talk about in a moment, that is a decision that's fraught with peril. And just because there's been a material breach under Georgia law doesn't necessarily mean you can terminate. You've also got to look at whether it's an interdependent obligation and whether the contract is severable. So again, don't take the plunge lightly here, or don't let your business people take the plunge lightly. And of course, here the last step on the spectrum is anticipatory breach. This is the price you may pay by misjudging where you are on this spectrum and terminating before the time for performance has come due. If you do that and you don't have a right to do so, you may owe the entire value of the contract immediately. This is something that business people find shocking, that you could possibly have to pay for the entire value of the contract, even if you think that the other side never could have performed, or they were so messed up from the beginning, no jury will ever believe them. Well, they don't even necessarily have to prove they could perform under Georgia law. Moving on, notice and cure remedy provisions are absolutely critical, and Georgia courts enforce them. They enforce them because they want parties to work through any problems and make sure there is, in fact, an irreconcilable loggerheads before litigation ensues. And business folks ignore these at their own peril. And I've already talked about the peril of terminating when you don't have a clear right to do so. Moving on, let's work it out. Compromise, compromise, compromise is the name of the game right now in these uncertain times. Not only because everybody is facing these difficult and challenging circumstances, and the court and an eventual jury will also recognize how difficult and challenging these times are, but also because the courts are not at present moving as quickly as they had been, and there is a backlog of cases building up that will likely take a while to clear. I will leave it to Mike Terry and Naveen Raman-Chandrappa to tell you more about their view on that. It's important to document changed arrangements, and particularly pursuant to the contract. And the reason I say pursuant to the contract is because no modification, or more particularly no written modification clauses, can be waived under Georgia law by conduct and by consideration. So don't compromise your way into waiving your best protection under your no modification clauses of your contract. And then temporary mutual departures are inevitably going to arise right now. Be sure, if you're going to rely on the strict terms of the contract, you let the other party know about that before you sue. Finally, last step here, I've entitled Call in the Cavalry. I tried to talk myself out of work over the last couple slides, and now I'll try to win my way back into your hearts. First, early involvement of litigation counsel in contract disputes and strategizing about them is a win-win. The home stretch before litigation finally does pop off is fraught with peril. Early termination can be catastrophic. And those final emails and letters that the parties are exchanging will be scrutinized over the coming months and years. Litigation counsel can help guide and also know when to fold a losing hand before a lawsuit is filed and the stakes rise even higher. And I know from personal experience, it's particularly challenging as a litigator to defend a lawsuit where the other side has been well counseled and strategized before they filed the lawsuit. And then you see the critical email or letter in the record, a couple weeks or months before the lawsuit was filed, and you are handcuffed, so to speak. And then my final point here is one that actually militates against filing a lawsuit, and that's a very significant change in Georgia law that happened last month. The Georgia Supreme Court has changed the rules around bad faith and stubborn litigiousness attorney's fees under OCGA 13611. It was a regime that worked where all the incentives were for the plaintiff to file a lawsuit as quickly as possible in order to have access to these attorney's fees. Now a defendant who has a counterclaim can recover attorney's fees for bad faith or stubborn litigiousness. And so my prediction is that we will soon see defendants winning bad faith or stubborn litigiousness fees against plaintiffs who race to sue without trying to work things out pre-suit. So this is a game changer under Georgia law. Nevertheless, 13611 remains a minefield for actually prevailing on and recovering your fees at trial. So another aspect that favors involving litigation counsel early. I will now turn over the reins to my colleague, Danny Vincent, to talk about a COVID timely topic.
Thanks, Pat. So I am going to talk about what impossibility in the time of COVID, and when does COVID make your particular contract and obligations impossible? So let's say you've done everything Pat recommends. You've collected all the things, you've tried to work it out, you've documented everything, but you find yourself in a courthouse in litigation or headed that way. You don't have a force majeure clause. But you're like, Danny, there is a global pandemic. How am I supposed to do all of these things? How can I perform under these circumstances? So you're not entirely out of options. Georgia has a statutory impossibility defense. It actually has codified the notion of an act of God. So, but it's very tough. There are actually two different statutes. So you have to be pretty sure that it's impossible and not just inconvenient. All right, so it is codified in the Title 13, which is the contracts title in the Georgia Code, and applies separate and apart, like I said, from any force majeure clause. 13421 says, if performance of the terms of a contract become impossible as a result of an act of God, such impossibility shall excuse non-performance, except whereby proper prudence such impossibility might have been avoided. So now you're asking, but Danny, what qualifies as an act of God? Fortunately for all of you, I found a Georgia Supreme Court case from 1847 to help define that. The Georgia Supreme Court said then that an act of God is any accident produced by physical causes which are inevitable, such as lightning, storms, my favorite, perils of the sea, earthquakes, inundations, which the internet tells me is probably floods, sudden death, or illness. So the three takeaways really from that are that it really does have to be extraordinary. It has to have been unavoidable, again, by proper prudence, and there can't have been any human agency involved. So let's take a look at the first two of those, extraordinarily and unavoidable. Pat? And this Cannon v. Hunt, this Georgia Supreme Court case from 1901, which is kind of a landmark case on this topic, and it tells us two important things. This was a contract to build a house. The builder had 6 months to complete it. They didn't start for 2 months, but they still had time to finish when they did start. But then heavy rains came that caused a bunch of delays, and ultimately they didn't get it started didn't get it completed by the contract deadline, sued for breach of contract, and here we are in court. And the builder said, look, it was impossible because of all these heavy rains. Like we couldn't physically build this during these rains. And the Georgia Supreme Court said that does not qualify as an act of God, that constant, unusual, or heavy rains of themselves cannot be classified as a providential hindrance. And so that's just a lesson in the sort of extraordinary nature of what that physical impossibility looks like. The second thing that this Cannon case tells us is that the builder, in this case, the court said, did not act with proper prudence because they had that 2 extra months at the beginning that they didn't avail themselves of. And so even though they had plenty of time to still finish it with the 4 months, that they had 6 months, and you don't get to wait until the end and then claim impossibility. So the next key piece on this, Pat, is the lack of human agency. So again, we have another Georgia Supreme Court case, this one from 1945 in the middle of World War II, 4-year contract to harvest timber off of some property. Obviously, there are a bunch of issues with that during the war, not able to harvest all of the timber to sort of the satisfaction of the parties. And the harvester says, look, we couldn't do it. It was impossible. See global war. And the Georgia Supreme Court said that although a terrible war, the war that this country is engaged in can in no sense be said to be an act of God. See humans. So human agency in that, even though it's terrible, is not going to do it. So sort of a recurring theme here, which is you're going to see that a force majeure clause could incorporate broader things. And so this statute is very narrow. It's broad in that it applies to everybody in every contract, but it's narrow in that it really only applies to acts of God, whereas your force majeure clause could apply, you know, to sort of whatever you agree to put in there, and often does apply to things like acts of war. So there's one other statute, an impossibility statute in Georgia, impossible conditions, which is broader than just acts of God here. So 1335 says impossible, immoral, and illegal conditions are void and binding upon no one. And so, no, okay. So the little arbitration cartoon there, this case from the Georgia Court of Appeals a couple of years ago, looks at the enforceability of an arbitration provision when the parties contracted to use a particular arbitration forum, a particular organization that has since gone out of business and they can't use anymore. One side says, look, the condition, it's impossible to comply with this provision, therefore we don't have to, it's void. The other side says, no, it's fine, we can just put in a different arbitration, we'll just use AAA or JAMS. The Georgia Court of Appeals says, nope, that forum clause was integral to the contract, and because you cannot comply with that, you have an impossible condition. Similar construction contract was subdividing lots, and the question there was whether or not, given the historical property ordinances and other city zoning ordinances, whether the property developer, whether it was impossible to subdivide those lots in order to fulfill the contract to sell them. All right, objective impossibility. So this applies to both the impossible condition statute and the impossibility defense. And that is that whatever the impossibility is, it cannot be a subjective impossibility. And that means that the impossibility, which is personal to the promisor, does not excuse performance. And so this most often, as we saw during the Great Recession, applies to the inability to obtain money. So poverty, financial panic, failure of a third party on whom you rely for furnishing money, when the Bright v. Stubbs case does not excuse non-performance in the absence of a contract provision in that regard. So again, this is what these very specific statutes will excuse, and the sort of non-performance that can be excused here versus what you would have in a force majeure clause. That cruise jewelry ship case is interesting, but I don't think I have time to talk about it. So now we're looking at COVID-19, right? Here we are, and you are you're here. Pat, would you change the slide? And so does impossibility apply to your contract? And so looking at all of this, is it an act of God? Does it create impossible conditions? You know, the short answer is that if you look at all these cases, it's an incredibly fact-specific inquiry. And, you know, whether or not it's going to apply, you're going to need a lot of analysis in that. You're also, as Pat mentioned, you're going to get into jury questions about the reasonableness of everybody's behavior, the reasonableness of your efforts to avoid the impossibility. If you don't have a specific time frame in your contract, the reasonableness of the, the fact question for what is a reasonable time to complete this project under these circumstances. And so you're going to let a jury end up, potentially trying to answer that question. So ultimately, these are just the default statutes. And so we would encourage you to, use your force majeure clauses going forward. be thinking about how you can smartly draft those so that you can control that more than having to rely on these. But if you need to rely on them, they're there. And that's it.
Hello, everybody. My name is Naveen Ramachandrappa, and along with Mike Terry, we're going to give you a short update on where the various courts in Georgia are at with their cases. I'm going to focus primarily on the state of the past, basically what happened in March, April, and May of this year. And then Mike Terry is going to give you an update on how courts are moving forward. And the reason that it's important to understand where courts have been is it'll help explain, one, the backlog that they face and how they are going to be addressing that. So, one of the first things that I did once the pandemic hit was to call a clerk. I called a clerk for one of the state court judges and asked him, what's it like? What have you been doing? And I think it's a lot of his experience. It was a little chaotic in the beginning. One of the surprising things I learned is that when they were sent home, they didn't entirely realize that they weren't be coming back for a while. So this particular law clerk had not taken any hard copy files of cases that he'd been working on. And while he did have access to electronic, pleadings, all the, courtesy copy binders that lawyers submit, he didn't have any of that with him. And so he expressed some difficulty in working on some of these larger cases at first. So particularly in March, we didn't see a whole lot of judges holding hearings by Zoom or getting much progress on new cases. And I say that in a qualified sense. While that was probably the majority of judges, we still had a fair number of Zoom hearings. There was a DeKalb County State Court Zoom hearings that were held, some in Fulton as well. But I think for the most part, most judges were just trying to get their head around what was going on and how to move forward. Then we get to April. And in April, we started seeing more and more hearings by Zoom or by WebEx. And, I think to a lot of people's surprises, judges were relatively good about doing them. They, I think they had a lot of help from their law clerks and IT, but they adapted, and a lot of hearings went forward. But again, these were hearings on cases that had either been fully briefed or were really simple. But I will say that in our experience, these hearings went by pretty smoothly. There was not many of the tech issues that people would have expected, nor were there the type of issues that made it seem like it was that much different from a live hearing. In fact, I noticed some of the same mannerisms from some of the judges that I would experience in a live hearing, including getting a lot of comments on my COVID beard. So, April was a pretty smooth month in terms of digital hearings, but not a lot of progress on getting people back in court for obvious reasons. Then we get to May, and the last couple of weeks, and things are starting to change quite a bit, particularly from the Supreme Court and Georgia Court of Appeals level. But one last thing I want to say about the trial courts is under the most recent order that the Georgia Supreme Court issued regarding the judicial emergency, the trial courts have been authorized to resume in-court hearings, assuming that they comply with physical distancing requirements, and they set up orders for their courthouses. So we're beginning to see some of those. Whitfield County is a good example. This is up in Dalton, Georgia. Their Superior Court has, they're going to do imaging, thermometer checks for people who enter the courthouse. They have had their deputies put place marks in courtroom where everybody's supposed to stand. They've even, capped the number of people who can enter particular courtrooms to ensure that the distancing requirements are met. So they're getting ready. And so in-person court hearings are coming, and we're already starting to see the signs of that now. So that's where we are on the trial court level. I will say that now that things are starting to resume in terms of in-person hearings, we're still not even yet to the jury trial stage yet, but just in terms of in-person hearings, I think that we're going to see an additional lag on the civil side of cases. I think judges are still going to be asking for civil litigants to participate by Zoom, but the criminal side is more likely to get some of them earlier in-person hearings. Now, with regard to the Georgia Court of Appeals, theirs was a little bit more straightforward. There were no arguments in March or April, and they transitioned to Zoom arguments in May this month, or last couple of weeks. And so we've had some of those arguments already take place, and they're going to continue that into June. If you look at the calendar, and I see this myself, I've got an argument on a date where there's 8 other arguments that are scheduled to take place. So they're really packing them in to make up for the last 2 months. But again, with an appellate court, this is a little bit easier for them to process, and it's not that much different from how we were doing things before in terms of oral arguments. Lastly, I want to talk about the Georgia Supreme Court. Georgia Supreme Court transitioned to Zoom arguments in April, so they had a little bit of a head start on the Georgia Court of Appeals. Their arguments went pretty smoothly as well. As we all know, the Georgia Supreme Court has been busy, though, doing a lot of background work. In addition to promulgating the judicial emergency orders, the Georgia Supreme Court was also making headway on applications for appeal, petitions for cert. And if you look at their docket, it looks, pretty similar to what it would look like if we hadn't had the pandemic. So within the Georgia Court of Appeals and the Georgia Supreme Court, I would say, largely speaking, they are back on pace and they are moving, but that makes sense because they're dealing with, purely legal argument. The trial courts are going to be behind. They already are, and they will continue to be, but things are quickly changing. They are, like I said, they're resuming in-person hearings in the next month, and they are continuing to make progress with digital hearings. And one note that I've been getting a lot of questions about lately that I want to make sure everybody understands is that in the latest Georgia Supreme Court order, they authorized all the courts in Georgia to resume deadlines in advance of the judicial emergency terminating on June 13th. However, the court has to affirmatively take those steps. So for now, the emergency period continues until June 12th, I believe is the last day. But courts can affirmatively reinstate deadlines. The Supreme Court itself has done that. So for any case in the Georgia Supreme Court, they have reinstituted deadlines. The Georgia Court of Appeals has done that in many other cases, but they haven't done that in all other cases. And then similarly, state courts and superior courts, they can do that. And we've been seeing judges sort of make that move and sort of ask parties, when are you expecting to file your briefs, so that that process can start. But until an order comes out saying that your deadlines are reimposed, it's still subject to the tolling. So with that, I'm going to turn it over to Mike Terry, who's going to give you an update on where things are moving forward and when we may see our first jury trial.
Thanks, Naveen. I'm going to jump back a little bit. It's been an interesting time. I've now had 11 Zoom arguments. So, that's been, I've had them in the Court of Appeals, the Supreme Court, and 4 different trial courts. And they've all been slightly different. And one of the things that the lawyers have had to do is modify their skill sets. And so learning how to use the exhibits, learning how to place things, how to use your cameras, how to focus on the camera lens rather than the pictures of the judges when the judges are talking. It's all a little bit different, but it's the same skill set primarily. I do want to also mention something else that has been going on during this time period, which has been interesting, is Zoom mediations and arbitrations. And I've been through 3 Zoom mediations, and I highly recommend it, guys. In my mind, it is actually at least as good a process as in-person mediation. It has a lot of advantages. And I think we're going to see a lot of people stick with Zoom mediations once the emergency is over. Now, let's talk about where we're going to go from here. As Naveen mentioned, we've had 3 orders from our Supreme Court, and the first was a shutdown order that basically stopped all in-person hearings, all grand jury proceedings, all jury trials, and extended all deadlines, including statutes of limitations. The second order extended that as well. The third order was a little bit different, and the third order, which extended the deadlines through June 12th and extended the emergency through June 12th. Basically, as Naveen said, created a number of exceptions. And it allowed the lower courts by order to exempt themselves from the stay provisions and the extension provisions for particular pending cases. Now, interestingly, before that, I had seen the Court of Appeals do exactly that. They had asked us in several cases, please go ahead and file your briefs despite the Supreme Court extension order. Please tell us what day you will file your briefs despite the extension order. And in one of my cases where the other side declined to file the brief because of the extension order, they received an order from the Court of Appeals saying, well, here's your deadline, do it. That has now been authorized by the Supreme Court. Now, for Naveen and I, who work a ton in the appellate courts, there's a reason that things have to move more quickly in the appellate courts. In Georgia, we have something called the 2-term rule, which puts a deadline on the Georgia appellate courts. It's in the Constitution. They have to decide all of their cases within 2 terms of court. So they can't just sit around for 3, 4, 5 months without making progress on the cases. And that's why they've been a little more aggressive in pushing. Now, one of the things the Supreme Court did in conjunction with and just before issuing its third order was it reached out to a number of bar groups, the State Bar of Georgia, the GDLA, the GTLA, the Chamber of Commerce, a number of other specialty bar groups. And it asked for advice and input on what should happen with the extensions, how we should get out of it, how we should resume, what safeguards, what priorities. So, hang on a second. So the thing that we have now is a committee formed by the Supreme Court. Sorry, I'm getting text questions from audience members. We'll get some of that in a minute. So we now have a committee that has been formed of the Supreme Court, and it is taking input from all of these different groups. And we are basically trying to come up with a plan for how to safely and promptly reopen. And there are a number of different subcommittees. How do we get jury trials going again? How do we get in-person court hearings? How do we get grand jury proceedings going again? Now, the one thing we've seen is that, as Naveen mentioned, the Supreme Court has authorized us to go, courts individually, to get moving. Well, what are we seeing? Well, the trial courts around Georgia are planning jury trials currently as early as the 3rd week of June. There are cases that are currently set the week after the current judicial emergency expires. Now, I think many of us think the judicial emergency is going to be extended. I think that is the prevailing wisdom. We don't know for how long, and we don't yet know the full terms. I believe there will be more leeway given to individual courts to move forward with things such as grand jury hearings and jury trials. Certainly with in-person hearings, they're already authorized, but there's going to be more guidance provided and more leeway given to individual systems. So that committee continues to meet, continues to work on guidelines for reopening. Right time. In 2008, the Chief Justice of the Supreme Court, the then Chief Justice, appointed a committee to try and figure out how a court should handle a pandemic. At that point in time, we were looking at bird flu, and we drafted a plan. I was appointed to that committee and served on the committee, and the head of that committee was the youngest justice, Harold Melton. We drafted a plan and we drafted a statute that allowed for the declaration of judicial emergencies, which didn't exist in Georgia. And we were extremely fortunate that when this came about, that young justice on the Supreme Court happened to be the chief and was in the position of having really more knowledge about this area than any other person on the court. And he was the guy who got to make these orders. And he's done a great job and been very receptive to input, very proactive, and extraordinarily protective of our court personnel, our lawyers, litigants, and jurors. So I think that's been just a great thing for us, that we had the right guy in the right place at the right time. Now, a couple of things that are being considered. For reopening jury trials, some of the courts are going to be doing them in their local civic centers or auditoriums. Some of the courts are going to be using larger spaces and big conference rooms for jury deliberations so that people can be spread out. Jury selection may take place in nearby auditoriums or even high school gymnasiums so that there can be social distancing during the questioning of up to 48 people coming in to be questioned for jury duty. So these are the type of plans that are being individually designed by courts around the state. How can this be done safely? In some areas, they are planning Zoom trials. So far, the Zoom trials are 100% voluntary. Everyone has to consent to that. It's not going to happen without consent at this point. Now, the federal courts in Georgia are moving a little faster. The Northern District of Georgia, the district of the federal courts here at Atlanta, has announced that grand jury proceedings may commence next week. So grand jurors could be brought in as early as next week to deliberate and consider indictments, et cetera. And jury trials are scheduled to recommence in July in the federal court in Atlanta. That is not what a lot of other federal courts in the country are doing, but there are others that are even a little bit ahead of that schedule. Again, the chief judge of each district has been given great discretion and is exercising that discretion based on conditions in their district. I have not yet heard what the plans are in the Northern District for how they're going to pick juries, but they do in that building have large auditoriums available. They could adequately spread people out, but I do think there's a serious question as to whether we're even going to be able to get jurors to respond to a jury summons. And so I think the no-show is going to be very high. And right now, I think we are, for example, I think it is likely that it's going to be a mask mandatory jury service. And there are those who are extraordinarily worried about people refusing to wear masks. And there are some lawyers who are worried about trying to pick jurors without being able to observe the entire face of the juror. One program that is being pushed at the state level is Georgia law allows for 6-person juries, but any party can demand 12 in a civil case. And there is a push on to get people to agree to the 6-person juries because you will need to bring fewer people in for jury selection to pick a panel of 6. You will have fewer people in the jury room, and all of this will allow for greater social distancing and greater safety. So that's going to, again, require the consent of everyone at this point in time before we can have 6-person juries. They're authorized by statute in Georgia. They happen in federal court every day, but in Georgia, every party has a veto over the 6-person jury, and convincing people not to exercise that veto if they happen to think under the facts of their particular case they'd rather have 12 than 6 is going to be an uphill battle in some areas. I think I've used all my time, unless anyone has any questions. Jeff, back to you.
Great. Well, I'll just pick it up from there, Mike, if that's okay. Good afternoon, everyone. My name is Mark Ray. I'm a partner with PwC here in Atlanta. I lead our incident response practice and cybersecurity practice, the teams that do a lot of preventative cybersecurity work for a lot of your companies and other companies around the country. Also here with my colleague, Kamal Ghali. Kamal, I'll let you introduce yourself and then we'll discuss our topic.
Kamal Ghali, an attorney at Bondurant, where I lead the cyber and digital litigation practice. Before that, I was a federal prosecutor for 6 years and served as the deputy chief of the cyber and intellectual property crime section at the U.S. Attorney's Office here in Atlanta.
Great. I will try to make this work, sharing some slides that Kamal and I put together for you here today. So thank you for having us, first of all. Changing gears a little bit, obviously, from the topics that have been discussed so far to the cyber realm, if you will, cybersecurity realm. As we talked about here, this pandemic has actually is a paradigm shift for a lot of things. Cybersecurity is no exception. With the majority of workforces going remote right now, it is a whole new landscape, if you will, in terms of the individuals and the people and the tools required to provide proper cybersecurity for your companies, and even in specifically in the legal industry that most of you work in. We've actually predicted at PwC, while we use the term the new norm, and I think there's subjectivity, right? What that really applies to, but I think when it comes to working remote, we predict that at least 25% of the workforce may never go back to an office formally. Hopefully everyone will be back at work, but a large portion we predict will not ever need to go back to an office. So from a new norm perspective, when it comes to cybersecurity, this is definitely, it has to be rethought in terms of how we defend our corporate networks and our private information. Come on.
And it does, yeah, I think, I can agree with that. And also there was such a push, I think, for organizations just to have business continuity going, meaning can we even operate remotely? And now kind of a couple of months in, I think some organizations are feeling good about the fact that they were able to transition to remote work. But the danger is that organizations confuse being able to work remotely with working remotely in a secure way. And depending on what data you look at, it can be weeks, months, or years before a cyber intrusion is discovered. And so the challenge will be figuring out, well, look, just because we are able to remotely work and log in and it looks like things are fine, does that really mean that we're not experiencing any number of data security incidents?
Right, that's right. So, what we're going to do today is we're going to walk through what a couple, really just scratch the surface on what some of those challenges are for a remote workforce when it comes to cybersecurity, and talk about how that's translating into the threats that people like Kamal and I deal with every day, and what we're seeing, how we're seeing those tactics change, and then hopefully leave you with a few, from your perspectives, what can be done about it, both from an individual perspective as well as a corporate perspective. So to set the stage, why is this such a big issue from a cybersecurity perspective? What I want to explain is that, as many of you are probably aware, that a lot of today's cyber attacks that we hear about, big data breaches, they have an initial way in which they happen. Someone gets a phishing email, something like that. But for the most part, they don't really utilize fancy malware. We hear about ransomware and things like that. But I can tell you from experience that a lot of these really sophisticated attackers out there, they're using basic techniques such as stealing credentials, stealing our usernames and passwords to get remote access. And then they have carte blanche access to our corporate networks, and they do what they want. They steal our information, they deploy ransomware, they extort us in some cases for our information. But the key is that initial foothold they do, which is getting remote access. So by having most of our employees working from home, we've significantly increased what we call our attack surface, right? Now we are all those remote people trying to get into that corporate network, just like the bad guys are every day. It's a lot easier before, significantly easier, I should say, for our security professionals to defend what they know, what's within the walls of the corporate network. But now with people trying to access corporate resources remotely, it's significantly increased the amount of monitoring and false positives that are occurring. So it's putting a lot of strain on security teams going forward.
And one way to think about it is really every level of connectivity is another choke point for attackers. So personal Wi-Fi routers, if folks are using their own personal devices, whether it's a laptop, whether it's a cell phone, those are all different opportunities for malware attacks, ways to get into networks. And then you're also seeing the flip side of that. It's not just that folks may be accessing networks with personal equipment, it's that they may be using work equipment for personal reasons, or parents that are letting their children use computers so that they can use Zoom to connect with school or friends. And so whenever you see that blurring between work and personal devices, those are all just additional opportunities for attackers.
Yeah. Yeah. And I can tell you from firsthand experience, someone who's done that, we, the security team spends so much time securing those work devices. But I can tell you, most of us work at large companies, but there's a lot of small, medium companies that didn't have that infrastructure in place, and they had no mechanism for people for working from home. But in a fever for maintaining business continuity, of course, use your kid's iPad, use that home computer that everyone at home uses to surf every type of website. Do whatever it takes to get online and access email and other corporate resources as need, company resources. It certainly increases the risk level out there. One other point I have here that I wanted to make was about distractions abound, leading to cyber vigilance fatigue. That's kind of a mouthful, but what I mean by that is, if we think of at least our current normal now, which is working from home, some of us may have kids that are we're helping homeschool, and just all of the distractions that come along with working from home, 5 days a week, sometimes more. We let down our guard in other areas. And what I mean by that is the cyber vigilance. That's something that many of you have probably gone through phishing training and cybersecurity awareness training in your companies, in an effort to stay connected or just get the job done working from home with all these other distractions. We do let that fatigue down because, I can tell you certainly during this time right now, in the security industry, we talk about 3 pillars, which are people, process, and tools. And it takes all 3 of those things to make a true cybersecurity program. That 3-legged table is leaning extremely heavily on the people leg right now. We are the forefront. We are out there, increasing this attack surface, as I mentioned. So we have to stay vigilant and just use good cybersecurity hygiene as we're supposed to, even though we're working from home. Come on, I don't know if you had anything else on that.
Yeah, I mean, just to make one point on strains on security teams, one thing we've seen is just the amount of personal strain on IT staff that aren't just doing all the traditional security functions, but are doing everything from running different types of equipment to different employees, making sure that workstations are stood up. And so you really have not only new roles that are being invented as the crisis unfolds, but kind of a long-term strain on the ability of IT departments to focus. And that's something that just comes with the territory of getting huge organizations outfitted for remote work.
That's right.
So we've identified a few areas here just to kind of assess the threat landscape in this environment. And this isn't the entire universe of cyber threats, but there are 5 types of threats that, in our view, really thrive in an environment like this. So the first is insider threats. Obviously, insider threats existed before COVID-19. They'll exist after. And you're essentially talking about employees and your own people and the threats that it poses to data security. That can be anything from downloading and stealing intellectual property, a disgruntled employee sabotaging a network. It might even be someone who's leaving the company and then steals customer lists on the way out. So what was always a problem is now really you have the same situation on steroids where a lot of organizations have their folks that are physically not there. The element of physical security that was present before, where people had to log into a physical place, there were at least eyes on other employees. A lot of that is gone, and you have a lot of opportunities for unsupervised misconduct, and it really puts a premium on network security to detect issues. And so, not to jump ahead to state-sponsored attacks, but some of this also goes hand in hand with an initiative the Department of Justice announced back in 2018, which was to address the phenomena of insiders that are funneling information back to the Chinese government, stealing intellectual property and sensitive and proprietary data. So as folks are removed from the day-to-day culture of a company, as they're working alone in their homes, you'll see an uptick in these types of threats.
Yeah, and I'll just chime in here, Kamal, and we'll go through the list here. But look at one thing I wanted to mention of all these things. Per usual, whenever there's a headline grabbing, world capturing geopolitical issue of some kind, per usual, these criminal attackers take advantage of that, right? From multiple perspectives, especially around, and again, not to jump ahead, but especially around the phishing schemes. I'll talk about that in a second. I'll go to the next one, which is ransomware. Kamal, jump in and take that. I can tell you, you're dealing with data breaches every day. Right now, haven't seen a huge uptick or any kind of unusual strains or unique strands of ransomware associated with this crisis. However, in this new normal, as we've been referring to here, from a cybersecurity perspective, the ability to conduct these attacks is going to expand greatly. Again, workstations that are unsecure, and especially as we move to this virtual environment, a lot of your companies, I think, will now be moving to more virtualized environments. And what that means is maybe instead of that server being hosted within the data center in the office, it's going to be at a hosting company. We're just moving that risk or that vulnerability around, basically, but it's still exploitable. Software as a service, as more and more companies go to that does reduce the risk of ransomware, but it's still going to be one of the major threats that we see. And again, virtualized environments don't really defend us as much as we'd hope from ransomware. We have seen enough. Oh, go ahead.
No, just the one twist, I guess, that we're seeing on ransomware is it used to just be lock your computers and pay the extortion fee to get your data back. And now you're seeing active data leaks where if organizations aren't paying, there's a difference in MO and attackers where they're actually leaking company data online, publicly disclosing it. And so there is kind of a harder edge that has been publicly reported just within the last few months.
Yeah. Yeah, and the third one we have here, of course, this is a very concerning, just simple video calls like we're doing here, exploiting video communication protocols. Unfortunately, again, in this new environment, in a rush to maintain business continuity and communications with our clients, with our coworkers, even with our family members, right? We're very fortunate that the technology exists, that the internet is there and is just available for most of us on a daily basis. And that a lot of these companies like Zoom and others have provided these tools sometimes for free for people to utilize. But almost like, I look at it almost like the .com days back in the late 90s and early 2000s. Security is always the last to be thought of. That's not exactly true here. We are, obviously in a state of where people are generally, especially from these technology companies, aware of security, but they're not that hard to exploit. It's not that hard to get the login information for a confidential Zoom call. So privacy, information privacy and intellectual property theft is of great concern in this new environment when everyone's on video calls and conference calls constantly.
And especially some of the public reporting on issues with Zoom and these other video communication protocols, really it was rooted in user error, where there are default privacy settings that weren't activated. And you might see that across a number of different types of communication protocols. So I think that puts a premium on organizations to make sure that if they're relying more on these types of programs, to make sure that they are activating some of the privacy features that are built in.
Yep. And then I'm just going to, in the sake of time, I'm going to cover the last two real quick. State-sponsored attacks, they're always there, creeping in the background. And much like the criminal threat actors, they always prey on headline-grabbing events to mask and cloak their true activities. We're quite confident that they are active right now. There's even been a lot of intelligence indicating that they're the typical actors that you would assume are actively seeking information about, of course, remedies and anything else pertaining to the virus research that's being done. And then phishing schemes, as we mentioned at the beginning, again, it's headline grabbing. And of course, there's some examples here on the right side of this page as well that a lot of the threat actors are using, the CDC and Johns Hopkins and other World Health Organization, even your own companies use it, but just preying on that susceptibility of people to want more information about the crisis and about the virus to click on things. Even requesting information. So those are obviously things every day that we need to be aware of.
We're going to just quickly run through a case study on an insider threat prosecution and draw a couple quick takeaways. So on April 16th, 2020, the U.S. Attorney's Office in Atlanta announced an arrest of a former executive of a healthcare company. And what happened was the healthcare company exists in the space that ships essentially personal protective equipment. So gowns, goggles, masks, the kind of equipment that folks are using on the front lines to deal with COVID-19. A VP of finance was hired by this healthcare company back in 2016, works there for a couple years. Around December 2019 is disciplined, and by March of 2020, there's a decision to terminate this employee. Before he's terminated, he essentially had administrator access credentials, meaning he had essentially a run of the entire computer network. He was able to log into the system shortly before he was terminated, created a fake account, meaning an account that had no other purpose, and then 3 days after he got his final paycheck and was out of the company, hacked into the system using that login and password that he created, and deleted or modified over 100,000 records that ended up really wreaking havoc and delaying the ability of the company to ship out those, the personal protective equipment to healthcare providers. So there are a couple key takeaways. One is when it comes to insiders, it's really important for organizations to make sure that when they give, whether it's administrator access or any kind of permissions to access the network, that employees only access parts of the network they need, and the dangers that there are with giving certain individuals too much access. The other side is that law enforcement is taking these threats very seriously. This individual was terminated on March 26th, and he was arrested by the FBI as of April 16th. And so you have a local FBI office here in Atlanta that is very responsive, especially in this environment. And so this is just a good example of some of the different threats we're talking about playing out in a specific prosecution in this environment.
Right. So, lots of doom and gloom, right? But what could be done about it? And we want to leave you with just the last couple of minutes with just the high level kind of really practical things, right? But hopefully something from your perspective, especially in legal roles, that is useful or helpful to you. But the first one is, and this goes for all of us, it's just following basic IT security protocols. I mentioned those three pillars of cybersecurity earlier: people, process, and tools. And again, especially from a corporate perspective, companies are extremely hoping that all of that cybersecurity training and awareness work is paying off at this point. Because again, there was a layer of, when you are in a physical office on the physical network, the average employee, there is a layer of protection there inherently, which is not there right now. So we really are requiring people, hoping that people will, follow those protocols that are in place, the ones that required them to do or not do something. Again, from a legal perspective, one thing is revisiting incident response plans. I assume some of you on the phone either are or closely associated with the crisis team or or part of the incident response plan in your company. For when something goes wrong, a breach, a privacy issue, something like that. But this is the time to really revisit them. I think, and I write them a lot for companies. I review them a lot. So many of them assume that there is a team sitting in a war room, as a result of a crisis, and that's not going to happen. So I think a lot of the communications protocols and plans that are part of incident response plans are probably not valid at this point. So it behooves us to really take a look at those.
And just lastly, with respect to cybersecurity insurance, a lot of policies actually end up putting the onus on the insured to make sure that they have adequate security in place. And so I think a lot of organizations want to revisit, has the way we've changed things, the fact that we're remote, that there is a deviation from what existed just a few months before, has it called into question whether we can invoke any of our policies?
Yeah. And the last point, which it was interesting because, Pat and Danny were alluding to this earlier when it comes to contracts, right? But specifically when it comes to our cybersecurity vendors and third-party providers, maybe some of you are aware, but I know that a lot of your organizations rely on many cybersecurity vendors to, as a part of what we call their security stack, to fulfill the full cybersecurity program. We don't know this. Do you know the state of those right now? Does your security team, or from a contract perspective, are they able to fulfill the SLAs or the service level agreements that are in that are in the contracts you have with them? Or do you unknowingly have a gap or an exposure because they're not able to all be in a physical security operations center with eyes on glass monitoring your company's network, or they're at home, unfortunately, with one monitor and they're responsible for monitoring, alerts and other nefarious cybersecurity traffic for multiple companies all at the same time. So, maybe that's you asking your security teams, have we asked those questions? Are we sure that we're good on getting the service that we think we're supposed to be getting from our cybersecurity providers? And with that, Jeff, I think we can officially turn it back over to you or answer any questions.
And thanks, Mark. This is Pat. So we did get one question here over the last hour, and it was, have any of you conducted Zoom depositions and what has been your experience? And I will briefly summarize my experience. I've both defended a Zoom deposition and taken a telephonic deposition. And my takeaway right now is to default to the simplest way to do the deposition, which is telephonically and mailing exhibits in advance in order to minimize the amount of friction and variables that can come up in the deposition. Generally, you only get one shot at one of these, and you don't want to leave it to having to go to the court and asking for another one, especially after you've used some of your ammunition, so to speak, with the witness. Of course, the deposition strategy is going to be critical. If it is, the key fact witness, that might favor a video deposition. But right now, my default is telephonic and let the person on the other side of the telephone get comfortable and then have a conversation. And when I did that, it worked out very well.
Can y'all hear me okay? Is that better? Sorry, I was a little garbled to start. So I just want to thank everybody for participating. And, those who had a little bit of an issue getting in, sorry about that. And thanks for emailing me, and glad you were able to do it. Thanks to all the presenters and Mark, especially. Thanks for joining us today. And we look forward to doing this again. I think this is all going to be part of the new normal. And, we're really pleased with how many of you participated. So thank you and have a good day.